Good afternoon, good morning, or good evening, as the case may be. My name is Paul Wrange, and on behalf of the European Society of International Law and the Stockholm Center of International Law and Justice, I warmly welcome you to this joint event. As many of you know, the 16th Annual Conference of the European Society of International Law was supposed to be in full swing in Stockholm today. Due to the pandemic, of course, it has been postponed until 2021, when I hope to see as many of you as possible. During ESIL conferences, it is customary to have a panel discussion of a current event. If the conference had taken place as planned, the topic of this year's panel would have been self-evident. The COVID-19 pandemic and its direct and indirect consequences have not only disrupted all our lives and ravaged the lives of millions of people around the world, it has also put some familiar features of international law in a new light. If law is a matter of balancing interests and values, then emergencies like COVID-19 pandemic force us to take a new, hard, and quick look at those values and interests, as well as to find a factual basis for any rebalancing, temporary or permanent, that we might want to make. Many issues and areas of international law have been implicated during the crisis: sovereignty, economic globalization, the roles of states and international organizations, individual rights versus public interests, and so forth. In this event, we will take a look at two general discussions which cut through many of the more specific issues, and which also are related, namely the role of information and the application of exceptions. I am very glad to have two excellent panels here to talk about these issues. The first panel, which we have called Science, Tech, Trolls and the Role of Information, will feature Gloria Gonzalez Fuster from Freie Universiteit Brussels, Marko Vilanovic of Nottingham, Jirje Priban, who will connect very soon, we hope, and it will be moderated by Philippa Webb, King's College. The second panel on emergencies, exceptions, and regime contestation will be moderated by Anne van Aken from Hamburg. And it will feature Gianluca Burci, Geneva Academy, Jürgen Kurz of the European University Institute, and Federica Pardeu from Cambridge. Let me also express my deep appreciation to my fellow members of the organizing committee, Anne van Aken, Gleide Hernandez, Philippa Webb, as well as to my colleague at Stockholm, Mark Klamberg. Before we begin, a few matters of housekeeping. In distinction to regular Zoom meetings, this is a Zoom webinar. As attendees, you cannot turn on your video cameras and you cannot unmute yourselves. As you will see, the panel discussion will be in the form of conversations rather than regular presentations with Q&A. We will, however, gladly entertain questions. And I now hand over the floor very briefly to Gleide Hernandez, who will moderate the questions, or who will assist the moderators in moderating the questions. So please, Gleide, explain how you would like to have the questions.
I will. Good afternoon, everyone, and thank you for attending. I see that we've got over 70 attendees, and we think that's splendid in these Zoom fatiguing days. What I'm proposing as chat moderator is that if you have a question that arises during the conversation, so as not to disrupt the flow of the conversation, please send a private message to me as a panelist. I will apply a bit of a light touch filter, and as I chat with the chairs of each panel, I will feed them the questions as appropriate at the proper moments, and they can decide either to interrupt conversation and take a question, or they will choose to reserve questions in batches or groups before the end. Please don't hesitate to ask the questions. We think it encourages interaction and debate, and we welcome them, and we hope to receive many questions for these panels, because we think it's a hugely topical issue. So I invite you to just send me a chat with your name, your affiliation, and the question as you'd like it to be posed, and I'll make sure that at the right time it is sent through to the chairs. Thank you.
Thank you, Gleide. So questions should be written on the chat box and directed directly to Gleide Hernandez. So we will not be using the Q&A button. I should also mention that between the two panel discussions, we will have a brief break to enable you to fill up your coffee or do a bit of exercise or what you feel like. So I now think it's time for me to hand over the screen to Filippa and to her fellow panelists. So Filippa, please.
Thank you, Paul. And I thank the Stockholm Organising Committee of Paul Orange, Mark Klamberg and Jana Pittman, who've made it possible to offer this ESIL event in the absence of being able to meet in person in Stockholm this year. So as Paul said, our first panel is Science, Tech, Trolls and the Role of Information. And I'm going to start with an overview of the key issues from our expert panelists. So turning first to Marco, you're an expert in international human rights law. And as you know, there is a global infodemic alongside the pandemic. We are being told by anonymous Facebook groups, world leaders, and supposed medical experts that the coronavirus can be cured by injecting bleach, getting some sun, or eating the poisonous leaves of the oleander plant. What does human rights law have to say on combating this viral misinformation?
Well, hi, everybody. It's nice to be with you, even though we're not in Stockholm, as we will all be together next year and enjoying the sunshine and the good food and everything else that Stockholm has to offer. So the topic, Philippa, you raised obviously is a crucial one today, and people are dying literally as a result of misinformation. Perhaps the worst such case happened in Iran a couple of months ago, where misinformation spread online that ingesting methanol was actually either a cure or a preventative remedy for the coronavirus. And it has been reported by Iranian authorities. To what extent is that another example of misinformation is a more complex issue, that some 700 people had died as a result of methanol poisoning, and that many others have been unwell or have went blind as a result of that poisoning. So the WHO quite rightly declared the existence of an infodemic. Now, as to your question as to what does international law and specifically what does human rights law have to say about it? Well, it depends. It depends primarily on who's the source of the misinformation. Because we can distinguish two kinds of misinformation. Misinformation that's spread by state actors and misinformation that's done organically by non-state actors, by normal individuals, online or offline. And the reason why this divide is important, obviously, is, as we all know, international law is a state-centric system. And effectively, international law will say to state actors that they may not, at least in some circumstances, may not spread misinformation, that doing so would violate human rights, whether that's the right to life, the right to health, or the freedom of expression and its passive aspect of receiving information. The other big issue is if states want to regulate the spread of misinformation online by normal people, by private individuals, or by third states, how can they do so without violating the freedom of expression excessively, without unduly burdening the freedom of expression? So we really have two sort of mirrors of the same coin.
And do you feel like international law is fit for purpose? I mean, some of these, you're talking about the not unduly burdening, on moderating, on allowing organic flows of information, but not to the point where people take risks to their health. Do we actually have enough law to guide us in this way?
Depends on what you mean by law. If you mean vague provisions and some nice older kind of case law that people like you and I, whose job it is to do this stuff, can interpret and make sense, you know, and make plausible and make relevant in this world today, then yes, we do have enough law, and that law is fit for purpose. And remember, the whole point of that law is that it is abstract, it is general, that it is potentially applied to problems that nobody could envisage when these treaties were drafted. On the other hand, it's also true that there have been very few specific cases that have been litigated on any of these issues, and that some points remain unclear or very controversial. I mean, let me give you one example. If, say, Russia spreads misinformation in the United States, whether that's about the elections or more concretely for our purposes, if it's about COVID, does the European Convention on Human Rights apply to the person in America who may have ingested some kind of poison as a result of Russian misinformation. Or if private actors from Russia are doing that, like some kind of hacktivist group or a corporate actor, does Russia have a human rights duty to protect people outside its territory from harm? And I can tell you, okay, there's all these relevant cases that sort of apply, the Inter-American Court's advisory opinion on the environment, for example. But exactly on point? No, exactly on point we're going to get as a result of everything that's going on now.
Yeah. And do you think that this is an area where the improvement of the law or the improvement of knowledge about the law is going to be on a sort of common law case-by-case basis? Or is this something that actually calls out for soft law or even a treaty?
I think both, right? In the sense, so it's inevitable that human rights law will develop organically, to use that word again, on a case-by-case basis, as sort of there's litigation, as there you have reports by UN special rapporteurs, for example, the outgoing special rapporteur on the freedom of expression, David Kay, his last report was on COVID. I'm pretty sure the new special rapporteur on the freedom of expression, Irene Khan, will have her first new report on COVID and so on. So that type of stuff will inevitably go on. Then you have sort of soft lawmaking kinds of initiatives, like the two Oxford statements on cyber attacks against hospitals and on cyber attacks against vaccine research, that are sort of efforts by us, by our kind of people, to sort of provide some kind of, sense or mainstreaming of some of these principles into very hardcore, well, maybe not hardcore, but relatively reasonably clear, bright line rules. You shouldn't try to disrupt vaccine research, for example, or you have the duty to prevent hostile actors from doing so. So I think, like always, international law will develop on multiple tracks. How effective it will be, that's a different question, right?
Well, we're going to come back to some of these issues, but I'm going to move on to our next expert. And I welcome Jiří, who has joined us now. Welcome.
Hello, and my apologies, but I apparently was registered as an attendee and not a panelist, so I will keep repeatedly. Yeah, okay, so thanks very much for having me.
We're delighted to see and hear you. So I'm just asking for a quick overview of the issues from our various panelists. So your fields of expertise include social theory and sociology of law, legal philosophy, constitutional and European comparative law, and the theory of human rights. And you've been writing about the pandemic, and you've observed that we can recognize how free and democratic a society is by how it deals with abnormal situations. When democratic immunity is weakening, we face the risk of the virus's absolute power. What does this pandemic emergency tell us about the state of our society, Jiří?
Thank you very much for these questions and comments. And I think that even we as theorists of law and international law in particular, we learned one important lesson, that those simplified and simplifying theories of state exception and the global society as one gigantic state of exception is a gross exaggeration and misreading of legal categories by some philosophers, mainly Giorgio Agamben. But in fact, we learned that the power of the executive isn't absolute, and actually legal practices, constitutional traditions, and what we can call living constitutional law, living constitution, plays much bigger role in this state of exceptions than we would be willing to admit a couple of months ago. So when you look backwards and you can see that each country had its own approach to constitutional issues related to COVID. UK, of course, with its sovereignty of parliament, passed a new bill which carefully regulated what the government can do, how it has to respond to parliament. Israel enacted a national unity government, and what I meant by the weakened immunity, democratic weakened, was the case of Hungary, where democracy was declining for the last 10 years. It was so easy for Prime Minister to launch a paradoxical autopoietic coup against the parliament in which he enjoyed a constitutional majority. So it was the full swing towards the executive, but it is impossible to explain by COVID. No, it has to be explained by what happened before COVID, and the responses and successes heavily depend on these constitutional traditions.
So that's really interesting. And if we're to push the health analogy, it's almost like if you have an existing precondition as a state, that you're more vulnerable to the worst tendencies in your executive or government to come out. So looking at the success stories of government responses to the pandemic, what are the constitutional features that you think prepared them well for this abnormal moment?
Well, it's, I'm afraid, too early to say which governments had been successful and which haven't been successful, including countries such as Sweden. But what we can already say is that two biggest powers in the world failed in treatment of COVID in their own way. Look at China and its complete international relations disaster in wake of COVID, and Indian-Chinese clashes on the border, Hong Kong, and we can continue on with this. Look at the United States. It's another failure of the country which is richest in many respects, which has the most expensive medical system and which has the most victims. So I think if there is a lesson to be learned already, COVID lesson is the lesson of growing internationalism and supranationalism, that like organizations such as the European Union, they cannot call the state of exception. However, without supranational and international organizations, it's impossible to resolve the impact and consequences of the crisis. So I would say that actually sovereigntist politics is a cause of the failure. But what is the success? Maybe there is a route towards more international and supranational cooperation to deal with the impact of COVID.
Thank you very much. I don't know if Marco and Gloria want to chip in at this point. If not, I'll... Marco?
I suppose, one interesting question in terms of like states of exception formally is how many states have derogated from human rights treaties with regard to COVID specifically. And I don't have the exact statistics at my fingertips, but my sense is that more states, about maybe a couple of dozen, have derogated with regard to COVID than at any time before, both from the ICCPR and the American Convention, the European Convention. However, the vast majority of states have not derogated. And that tells us actually that the vast majority of states probably did not think that, at least internationally, they'd need to resort to some kind of state of exception. That rather they could, through normal lawmaking powers, handle all the challenges of the pandemic, like, for example, quarantines or lockdowns and so on. But I don't think necessarily that success in dealing with COVID is directly related to constitutionalism. It may or may not be. So certainly, America's failure, and it's undoubtedly a failure, is largely a consequence of the kind of administration it has today. On the other hand, you have complete autocracies that have very little constitutionalism in any real sense of the word, like Vietnam or Thailand, have zero community transmission for most of the period and are very successful on those counts. So I don't know. I mean, I agree that there's a link. It's just not a completely direct one.
Jerzy, do you have a response to that?
Yes, I just want to elaborate briefly on what Marco said. It's one thing which was quite surprising was how carefully, even those states of exception within each country, how carefully they were crafted according to some constitutional patterns. So limited, proportionate for the purpose, and it wasn't like the full power to the executive, and we'll see it like what happened in Hungary, where the army marched into private enterprises. And second, I think it was clear that we lawyers tend to exaggerate the role of law, but the role of economy, the role of commerce and science is very important in this respect. And for instance, reopening of borders in the European Union wasn't caused by human rights arguments and limitations of freedom of movement, but simply by sheer necessity to restore internal market of the European Union.
Thank you. So now I'd like to turn to Gloria. Gloria is an expert on surveillance and data privacy, as well as artificial intelligence. In the name of public health, we've been providing lots of personal information to the government that we wouldn't have done in the times before the pandemic. We're all downloading tracing apps, submitting locations, scanning codes at various places, sharing our contact lists. So we've sort of gone from this great reticence that happened with the introduction of GDPR to now being an open book in some ways. We're also using a lot more Zoom and other video conferencing tools. So Gloria, what are the key dangers to privacy that you see arising from government responses to the pandemic?
Yes, so hello first. Hello everybody, good morning, and thank you for the invitation to be here. And this is a very good question, but a very difficult one. What are the main dangers? There are many dangers in the way there are many challenges, because indeed much of the response from governments has been data driven, so about looking for data. There is also this whole issue that our lives became digital because they were less and less real in offline, and many things went online, education, work, leisure, many things. Now, regarding specifically governments, why do they want to have data? I think it's interesting to see that they want to have data to take decisions related to COVID, and also to understand the impact of the decisions. I think one of the first things that government did, and also the European institutions did, was to ask for location data from telecommunication providers in an anonymous way. But so telecommunication services providers have all this information from our telephones. They can know where people go. And they wanted to know, when they took these decisions about lockdown, everybody must stay at home, but are people staying at home? How do we know it? We can go and count the cars on the road, or we can just ask these companies to tell us, well, indeed, we see that phones are staying here, or many people are moving. And this helps governments, public authorities to take decisions and to see if their decisions are having the impact that they want. Of course, this has privacy implications, and the GDPR that has a role to play, but there is this very tricky line there that this is supposed to be anonymous data. When the public authorities receive it, they say, well, we receive it in a way that we cannot link this data back to anybody specifically. Therefore, the GDPR does not apply at some point. And this we see the limits of the frameworks that we have to protect us. And yes, we see many challenges. There is another big challenge that relates indeed to contact tracing. You mentioned these contact tracing apps. I like to talk about contact tracing ideology, not to sound specifically dismissive, but I think it goes beyond the apps. The apps are one of the manifestations of this contact tracing policy, which is let's collect data, let's keep track of everything. in case next week this data will be useful because somebody will be infected and we might want to trace back something. This is a massive change, and I know that people who are especially promoting the contact tracing apps like to insist that this is not completely new. We used to do some contact tracing, like the manual contact tracing for cases of other viruses. And indeed, it's not new, but the scale of this is new, and this preventive policy, the idea that we keep the data when we just have a coffee somewhere, just in case, this is new. This is completely unprecedented. And so we have indeed new challenges, and I was listening to the question of, so does this raise a state of exception, an exceptional response? Generally, no. Generally, in Europe, at least the response has been, we have the GDPR, we will try to apply it when we can, because it can also favor the trust that people have on the systems, except indeed exceptionally in some cases, and Hungary was mentioned. Hungary indeed did not decide to suspend the GDPR, but they said for some of the provisions, we just put in brackets and they will not be applicable while the crisis is there. So there are indeed some states flirting with exceptionalism also in the area of privacy and data protection.
Thank you. Well, this leads into some questions we're receiving about, this idea about the constitutional health status of a government and the way it's responding to these data issues, to information distribution, dissemination, control issues as well. So we have a question from Mark Klamberg of Stockholm, and he asks, all governments say they rely on science, but they still adopt different strategies. What are the legal implications of the fact that experts have different views on what to do? Jiří, would you like to jump in on that one?
Yes, and we have cases in which courts in Germany, courts in Czech Republic intervened, and they declared void some ministerial acts or governmental decisions on limitation of freedom of gathering or freedom of movement. But I think this is a crucial question, because we know that science speaks multiple voices and very often conflicting voices, and the law has to speak one voice, full authority, and it makes life much more difficult, but at the same time independent for judges. So it tells us how scientific facts actually are not just one size fits all, and how law has to make its own, or constitutional courts, and they have to make their own mind about even COVID restrictions, but they are not related to scientific truth. They are related to our rights, freedoms, our safety, the duty of government to govern efficiently and administer rationally. So it's, if it proved anything, it proved that strategies by politicians and scientists will have to be coordinated, but at a higher level of coordinating authorities. There is no one single authority to tell us what to do in COVID times. And even authoritarian regimes, yes, they can do a lot of things, unlike democracies, but whether they are right or wrong things, we don't know at the moment. And they are unreliable in their statistics. Yeah.
So, Marco, if there's no single authority to tell us what the science is or what the law should be, as Jiří has explained, what does that mean? We should just have as much information as possible? Maybe, and I don't purport this, but maybe there is some role for methanol. Once again, that's just a very facetious example. But
I think it's a very good example.
Be too quick to dismiss the oleander plant.
Yes, which actually grows in my neighborhood, certainly. So yes, very, very convenient. I think it's we cannot simply say, well, anything goes. There's no authority. every opinion is equally valid as any other opinion. You know, there's no truth because there's no agreement on the truth. Whatever, I mean, no account, philosophically at least, no account of truth that simply relies on some kind of consensus makes sense. You know, people believe all sorts of people have believed all sorts of stupid things since ever there were human beings. You know, to this day, there are some people in this seminar who are taking homeopathic medicines, even though those don't work, or go and have their astrologer read them some kind of chart thingy. You know, like, what can you do? So that's normal. There are big questions of policy, and then there's smaller questions of law here as to how, you know, we should integrate science. If you think about the former question, you know, like the UK is a very sort of, I think, instructive example, in the sense that every politician there says, well, we're only listening to the scientists, you know, even when they're making clearly political decisions that balance competing considerations, like, for example, damage to the economy versus, you know, spreading the curve of the disease. They're always saying, well, it's the scientists who told us that, without ever acknowledging that the science may be uncertain, without ever taking political responsibility. But there's fact and facts, okay? So the issue that methanol does not cure COVID is a factual question that is not open to serious dispute, even if you find a random scientist on the internet who will say that methanol is fantastic, right? And so if you're running a criminal trial, you're a judge, and you're running a criminal trial for somebody who, for example, in South Africa, there's a law that if you deliberately spread misinformation with intent to cause harm, you go to prison, okay? And if a person gets prosecuted on that basis, the judge will have to establish whether methanol in fact causes death and does not cure COVID. And the judge will have to rely on expert evidence to do that. And judges do that all the time. Forget the pandemic. We always have to decide issues of scientific knowledge, right? On the other hand, there's other types of facts which are far more contestable, where, you know, the science is simply not yet there. So think, for example, the role of face masks. Okay, so at the beginning of the pandemic, you had loads of scientists saying face masks either don't work well enough, they might even be counterproductive. People will be touching their face while, you know, which might be contaminated by stuff from the mask. Don't buy masks. And then that changed, right? So that scientific consensus evolved. So certainly the law should be very, very careful in intervening in those types of debates. The question is, how can one recognize that type of situation from the methanol one? And I admit, you know, that's not always easy. Or today, for example, the big issue is not masks, unless you live in a crazy place. The big issues, for example, aerosols. You know, does the virus spread through aerosols, and what should we do about it? And certainly the law should not interrupt, say, free speech on these topics while the science itself is unsettled. And drawing a good line here is impossible to do in any kind of categorical way. It requires a lot of wisdom and prudence and common sense from those who apply the law and who make the law.
So we once again come back to the health of our institutions to protect our own health.
By the way, I want to go to New Zealand, don't you? Don't you want Jacinda to be your prime minister? So there are places.
I'm half New Zealand, Marco, so
there you go.
Already a plan.
Problem solved.
Gloria, do we see the same kind of unsettled and competing narratives in the data sphere as we do in the science sphere? You know, are there similar debates about how data should be best collected, protected, stored, and used?
Well, I have to say, all these controversies are very much, for me, they're very much interlinked. And I keep thinking about the contact tracing apps. And it's about collecting data, but I think that is a specific, very good example of issues where the scientific narrative and the policy narrative, but also like the normal people narrative, are in a context that is not didn't happen like this before. So basically, we have these apps that have been developed by experts, by scientific experts, epidemiologists, and they do the statistics calculations saying, well, what is a relevant encounter between two people that we should intervene, or will also intervene when people are closer than 1.5 meters for 15 minutes, and this makes it that you receive a notification. So you have the app, you want to be nice, and you want to save the planet, and you want to be notified when something happens, and you receive this notification of this case that, according to the expert, is scientifically relevant. But maybe you know that that case, you were wearing a mask, there was a plastic, and you know about many other cases where you were in contact with somebody and nothing happened, and the science has not seen this. And I think these kind of issues are very difficult for people to understand, that they put into question that, why should I trust this notification? Why is the law obliging me to spend 2 weeks at home because of the notification, and my neighbor is doing this and that and nothing happens to them? This is very, very strange. And I think we need social scientists, experts that will know that indeed, if you try to sell this to the population, it will conflict at some point. So there are, I think, these scientific questions are related to the data protection question, because for data protection, the main question is, which data do we really need? Which data is really useful to collect? And then we know, we take basic decisions about protecting data. But we cannot have separate discussions. And I think in the area of data protection and privacy, really the main, perhaps not even a controversy yet, or the main thing that has happened now with COVID is this whole discussion about privacy by design. Probably you have heard of privacy by design. It is in the GDPR. It's a good thing that we embrace privacy by design. We need the technologies have to be thought, designed, thinking about privacy, but we have somehow confused privacy by design with perfectly privacy legally compliant, which are different things. So privacy by design is for the GDPR one element of many others. And I think companies have said, well, it's privacy by design, therefore it's fine. And Giri was mentioning these two biggest powers of the world. When I hear in my world, the two biggest powers of the world, these are Google and Apple, and they are the ones who take decisions, and they decided that this kind of contacts that you have, Bluetooth encounters with people, are the one that matters for everybody, and they take the decisions. And for me, that's the kind of controversies that are solved very easily by them in some online meeting on Zoom, probably.
Yes, that's a very interesting point about who really are the powers and how accountable they are. I just want to ask one more sort of question under this category of experts, and then we'll move on to another theme. But Jiří, what is the relevance of peer review in this field? So, you know, it's one thing for a judge to filter through whether there's scientific consensus, but what about even within the scientific community? Is peer review our best check and balance, and is it fast enough?
No, it's peer review. Of course, science doesn't progress by consensus. Yeah, science progresses by falsification. Or what Marco said about truth is absolutely. I completely share this view. But science cannot tell us truth. Science can tell us what is false. So I don't like the expression fake news. No, it's not fake, it's false. And falsity is misleading and should be even legally prosecuted if necessary. So it's one thing in this whole realm of expertise. But I think that COVID revealed one important thing: the difference between science as that hard knowledge of episteme, yeah, that you know something which works, which can be verified, and science progresses by experiments. It's interesting, for instance, in the case of vaccine now testing, that Russia, authoritarian state, completely skipped one round of testing, and just to claim the victory over the virus, yeah, which is, I think, pretty obscene itself. And at the same time, the public opinion of doxa, and politicians work through doxa. They have to be elected in democracies, but at the same time, politicians have to listen to the scientific voice, which is most sensible and persuasive at the time being. Yeah, so that's very telling about the relationship between science and politics of science. And the example of the United Kingdom is really perfect example of 4 different administrations listening to different voices of medical advisors and ruling and enacting different rules on who can travel, who has to isolate from where to where, and it has serious implications. So science is fluid, and you asked about peer review. I said peer review is a lengthy and very unreliable method. I am very much in favor of experiments, and if it proves to be working, politicians should follow.
Thank you. It's interesting what you said about the Russian vaccine, because then on the other hand, you would have read that the Oxford vaccine had a negative reaction from one participant, and they immediately shut down the trial, gone back to the drawing board. There's a pause, which is against all the political and economic pressure that team must be feeling. But ultimately, that's for the best. I think most people would agree. Okay, we are grateful to have some questions coming in from the audience. So the first question is from Viviane Garval in Brazil. And she says, here in Brazil, there's a dispute between the federal government, which minimizes the virus, and the state governments of the federation. Science, politics, and law seem like mere speeches. Where can they find a supra-state coalition in the fight against COVID-19? Marco, Jiří, Gloria?
Well, nowhere. Or WHO. I mean, so unfortunately, each country, so the pandemic, despite being a global problem, what it has shown us is that each society sort of has to handle it in its own way, and it will suffer due to the various problems that are afflicting that society as a pre-existing condition. And unfortunately, that's the case with Brazil. It's the case with the United States. It's the case with Serbia, where I am now. It's certainly the case with the United Kingdom. And there is very little help that's going to come from the outside. Okay, so there is help in the sense of, you know, there are all these lovely scientists, people who are, you know, doing the vaccine research, whatever. But ultimately, there has to be somebody in the government who people believe in and who will be trusted in the public health messaging, who will be trusted when they say, can you please go get this vaccine? Who will be trusted when they say these measures are justified or not justified? And when you have governments that completely disrupt that trust between the governed and the government, you have a complete disaster. Whether the government is more autocratic or more democratic, that I think is the big lesson. If there's no really trust, you know, it's a recipe for complete disaster.
Jiří?
Yes, I agree, but this trust is changing and can change very fast. Yeah, trust in one government policy, if it flops, then it leads to distrust. I was always fascinated how Bolsonaro, for instance, responded in the most irresponsible way to the COVID threat. And yet, this populist denial was accompanied, apparently, by quite significant welfare benefits to the poorest in favelas. So even the authoritarians and populists are building their trust, and it doesn't have to be through scientific means. We have to beware. Politics and law and science, they don't translate immediately and that easily. So supra-state coalition in the fight against COVID requires also certain political style and I would say political self-limitation of political ambitions and power, especially in countries where you have coming elections, etc.
Self-limitation during an election cycle sounds like a tall order, Jiří. But we can be optimistic. So I want to go back to Gloria's very good point about when we talk about the powers, you know, should we really be talking about China and the US, or should we equally be talking about Apple, Google, Facebook, Twitter? Instagram, and the many other sort of means of social media, Weibo in China. So Marco, you've been telling us about the government reactions to misinformation and viral misinformation. But what have these social media and tech companies done? Have they taken this seriously, or have they been a source of the problem?
Well, kind of both, right? So in the sense that they are a source of the problem, their whole business model is what enhances the problem, because the digital platforms sort of reward attention-seeking clickbait. They reward this kind of emotional gratification you get from spreading something that is actually false or believing something conspiratorial. They reward people literally who spread this stuff because they pay them money, right? I mean, so that's how the system works. So if this happened, I don't know, 20 years ago when we didn't have these digital platforms, I don't think the infodemic would have been nearly as bad. There would have been sort of isolated islands sort of crazy stuff going on, but you wouldn't have a global infodemic. It's like today, you go somewhere random in Serbia, and they will say about how Bill Gates is inventing vaccines so they can microchip them. I mean, it's like literally like that. So that type of thing could not have happened were it not for the digital platforms. On the other hand, they're doing much more to combat this than they have done with anything else. You know how, especially Facebook, has been resistant to be what they call the arbiter of truth. And have long sort of resisted attempts to police political speech on its platform. Now they're doing more and more of that, even when it comes to high-profile individuals like Trump, because it's easier for them. It's easier to label something as misinformation when it's about health than when it's about Boris Johnson lying about the EU. I mean, it's simply it's more hard. However, all of these efforts, which involve taking down content, labeling content, employing fact checkers, counter speech, so sending people to authoritative sources of information, sending them to WHO, sending them here, they have some kind of effect. Are they mitigating the bad effect? They are. Are they doing enough? They're probably not doing enough, or at least it's certainly, the infodemic definitely is spreading. In parallel, you also have electoral misinformation. So it's interesting, to compare the two, to compare how the platforms are reacting to COVID-related misinformation and to, say, in the United States, electoral misinformation. And even there, they're doing now much more than they did 4 years ago. Some efforts, like state-driven misinformation efforts, the stuff that the Russians were doing 4 years ago, was much more effective than what the Russians were doing today. So there was a recent report by this outfit Graphica that works with Facebook, for instance, that shown that this, significant effort by the Internet Research Agency, this Russian trolling outfit, reached only 14,000 people today. Why? Because it's so much harder with all the automated and non-automated checks. It's so much harder to build this enormous audience you can spread misinformation to. So I don't know whether I answered your question. So they are doing something. Is the something enough? Is very hard to say. Should states intervene and start regulating these digital platforms? Yes, to some extent at least. Will they? They definitely yes. So we are now at the precipice sort of this enormous wave of regulation that's going to hit these digital platforms from all sorts of states, good states and bad states.
And yeah, one wonders whether from a technical point of view, how feasible it is. Gloria, do you have any comments on these private companies and social media platforms and their impact on both privacy or information circulating about data privacy and surveillance?
Yes, so I'm based in Brussels, and here in Brussels, just before the COVID-19 issue, we're all discussing all the time data policies and whatever policies, and the European Union institutions were very much into this artificial intelligence regulation, and also the European Commission proposed a new data strategy. And it was all about being open but assertive and having this more European, this digital sovereignty discourse about Europe being more assertive globally and trying to think this role of the European Union from a data perspective. With COVID-19, suddenly there is this moment of I think, great tension and many borders reappearing, physical borders, but digital borders also reappearing, and many national solutions there. And from a data protection perspective, data privacy, they try to say, well, we cannot like give a unique response European-wide, but we will at least encourage interoperability of solutions, like let member states have interoperable solutions. And this is probably only achievable with the technological help of Apple and Google, which are indeed not European, but American. And this, in a way, was bad news for all this moment of confidence and being assertive globally. And then at some point, just in this moment of crisis, well, we would just accept whatever Apple and Google decide. And what did they decide? Many interesting things. I think one of the most interesting is that they decided that they will allow for apps, contact tracing apps to be operating in Europe, but only one per member state. I'm in Belgium, which is a complex state, and I'm from Barcelona, that's another complex state. And so it's not easy for many states to have an app that is connected to a health system that in many cases is not a state national system. But there are many levels of decisions of who can stay at home, how, who is paying for what, education. These are decisions that are taken at different levels, but it's all simplified for this very specific decision that we will let Google and Apple decide that it's one per state and that's it, and there's no other solution. So this is just to give an example of how this has indeed implications for sovereignty, and then who is in a position to negotiate with Google and Apple the level of privacy of things that we have here. So for the other issue, the monitoring of social media, indeed, in principle, it must be at the European Union level that something happens. It should not be a national level, but now, God knows, I would say, because there are so many things that are really being diluted and popping up at a national level.
Thank you. We have some more questions from the audience, and we're also in our last few minutes. So I'm just going to ask a question that's been directed to Jiří. Peter Dankvart asks, could you develop your thoughts on why Giorgio Agamben is wrong regarding the nature of the state of exception? Has the pandemic not proved that governments can rely on extensive constitutional emergency powers to protect life from the coronavirus?
Okay, yeah, thanks a lot for the question. First, I would like to emphasize what Gloria said about these private sovereigns, yeah? And I think it's extremely important because it also sheds light on why we cannot use this state of exception formula that easily, because and what Marco said about information, and I think it shows two different problems. First is whether we have freedom of expression and how it can be limited, and whether exceptional powers can be used against it. But the second question through these networks is data. Who digs data and how data are used? And it's a very different question from constitutional freedom of expression and its limitation. It shows that there are private agencies that dig our data, that have can exercise enormous powers, and the states can, yes, they can curb. The question is who can limit Google, Apple, but if they join the forces, they can create a potentially gigantic data digging network where private and public conflates and merges into a very undesired global situation when we are victims of our own data. However, responding directly to the question, I meant that argument made early by Giorgio Agamben in early spring this year, who said basically that governments will be abusing the situation, expanding their powers as if there were some conspiracy on the side of governments against citizens and population, which of course wasn't true because governments were responding, and often chaotically responding, to the emerging situation. So that was my point. I know we are short of time, so I will stop here.
Thank you, Jerzy. Yes, we have time for just one last question, which comes from Faye Pazatsis, our ESIL president. So of course we must close with that. And she asked all our panelists, and I will ask you for a very brief comment from each of you, how can international law play a role, if any, on an equitable worldwide distribution of a vaccine, assuming that we have one?
Probably only to facilitate it formally, not in any meaningful way. I mean, meaningful, it has to be a political decision, and there's already a WHO consortium to sort of produce enough vaccines for poorer countries and so on. But definitely what we're gonna see is that the richer will get the vaccine before the poor in greater quantities. I mean, that's just, I don't see how else it's gonna play out.
I agree. It's a question of global distributive justice, but also of big, not profits, but investments and costs that have been made, and companies will want to get their money back. Maybe it's a challenge for the global redistribution, and ask even not just the states, the rich states, but the rich companies to contribute heavily.
I can only agree and say that it sounds like a logical finding after our discussion.
I agree. And, you know, maybe if we succeed in it, it'll be a model for other global challenges such as climate change and so on. Well, thank you to all of our panelists for really stimulating discussion, and to our audience for great questions and attention. We're now going to have a 5-minute break. As Paula said, stretch your legs, refill your coffee cup, and then we will move to the second panel chaired by Professor Anne van Aken. Thank you.
Thank you.
Thank you very much. Thank you.
Hi, Paul. Can you hear me? I can't hear you. I think you're muted. Okay.
Now I'm unmuted.
Oh, okay, now you're good.
Okay, so are you ready?
I'm ready.
Okay, and the other panelists? I can see that they are ready.
Federica is there. Everybody's there.
Okay, so let me first thank the moderator and the panelists for the first panel, which I think was really fascinating. And I'm now sure that we will have an equally interesting panel. So I leave the screen to you, Anna, please.
Many thanks, Paul. And also from my part, many thanks to the organizing team in Stockholm. It's a pleasure to chair this panel, and welcome back, and thanks for joining the second panel to the audience on COVID-19 and international law, emergencies, exceptions, and regime contestation. And let me start with Gianluca, who was already introduced. All of you have been introduced by Paul. Gianluca, you know the WHO inside out and are the expert on international law, health law. The WHO is central to the debate on a multilateral response to COVID. Recently, in an article in the American Journal of International Law, well, actually it's forthcoming, but Jose Alvarez identified some critical issues in the WHO. An inability to overcome its state-centered roots, over-reliance on soft law techniques, inflexible emergency declarations, an absence of institutionalized mechanisms for cross-regime collaboration, and the blind spots and pathologies that arise when experts become bureaucrats. Which of those critiques do you deem justified and most relevant, and how should the WHO go forward? And that maybe connects to the question of our president in the last panel, if you want to extend it there.
Thank you for inviting me, and I hope you can hear me and see me decently well. Let me just say that the reason why Anna said that I know the WHO inside out is because I worked there for 18 years. So I have a little bias in favor of my former employer, but I'll try to be as objective as I can. Jose is right. I mean, I can deny that his sort of indictment on WHO is more or less correct. But I think that what he says has to put in context, and in a number of contexts. Some of these considerations apply not just to WHO, but to most international organizations. The state-centric roots, frankly, is a common features of international organizations. The issue of autonomy, as you know, is something controversial and frankly quite unresolved with in scholarship and international organizations, and WHO is no exception. I think it depends, as you know, on many factors, on the leadership of the organization, on the particular politics of the issue area, on many aspects. In the case of WHO, I would add on the funding model, because WHO is so reliant on voluntary contribution that decreases its autonomy even more. But at the same time, and I joined WHO from the United Nations in New York, so I really could make a comparison, even though a bit anecdotal. WHO enjoys quite a level of autonomy, in particular when it comes to normative functions in more technical area where the power of expertise, and I go back to the first panel, weighs quite a lot in ensuring a modicum of autonomy and of independence to the Secretariat. And here I come to the other point that Jose mentioned, the over-reliance on soft law. I think soft law has been the success story of WHO. I think it would be unimaginable for a technical agency, in particular in a field like public health, to imagine that it could wield a stick or sort of a harder normative powers. So in a way, soft law has been a right instrument given the particular features of the politics of public health. Obviously, it has its limits when it comes to matter of high sensitivity and particularly important from a sovereignty point of view. Obviously, it shows its weaknesses. But again, I don't think it's something exclusive to WHO. It's the nature of functionalism, the nature of the particular model of international cooperation that has been expressed in international organizations as we know them. Jose says something very right, that there is quite a challenge in having like cross-regime cooperation and fertilization. That's something that I think goes beyond WHO, and that's something will have to be discussed seriously in the aftermath of COVID, given the devastating effects of health measures on the economy, on human rights, on transportation, on investments, and so on. But that requires a holistic approach. It cannot be just WHO. In a way, the sectoral approach of international organization, the functionalist model, in a way, don't give WHO the kind of leverage that can be used to build these bridges. The bridges have to come from different directions. And finally, on the international health regulation, it's true. It's a very ambitious instrument, but it's been negotiated in a record time and with oversight probably, and with, of course, resistance from states in giving up too much of the sovereign powers. So there are flaws that I hope we can discuss during this panel. And one of them indeed is unrealistic system of alert that relies on the concept of emergency. Either you have an emergency or you have nothing. Reality is more complex, and definitely that's something else that will have to be looked on in the near future. Let me just finish. The WHO has just appointed 2 panels to look at the lessons learned from COVID, both from a WHO perspective and from a larger systemic perspective. So I hope the states and WHO and the industry also, as Giri said at the end, will exploit this window of opportunity, because clearly COVID has shown the unsustainability of the model that we have. So WHO is, again, guilty as indicted, but up to a point, and it has to be put in a broader context. You're muted.
Thank you very much, Gianluca. I think that is already very interesting, and I think it will guide us a little bit in the discussion. But I gather that one thing is for sure: they need to change their funding model, and they can, given all the goodies they have for states. They might ask for a little bit more money, and as a non-voluntary contribution, which I think by now is about 20%, the non-voluntary contributions. Let me turn to Federica. You have just published your book with Cambridge University Press on Justification and Excuse in International Law, Concept and Theory of General Defenses 2 years ago, very timely, obviously. So when reflecting on exceptions and justifications, as in RZIVA in general, is international law overall well equipped to deal with pandemics, and does it give enough flexibility to states?
No, I don't think it does. Certainly not from the standpoint of the general law state responsibility. The defenses and exceptions that are contained in that document were deliberately drafted to be very restrictive so as to avoid the scope of states to abuse them. After all, they're often invoked in circumstances where there is no third-party dispute settlement that has power to assess the legality of their invocation. Now, there are 3 that are particularly relevant to this situation, all quite strictly drafted. So force majeure, necessity, and distress are the ones that have been argued most recently. And to just give you a flavor of how strict they are, I'll pick a theme that is common across the 3 defenses, a question of choice and the degree of choice that states have to take action in the circumstances and be able to rely on these defenses to justify or excuse, as the case may be, their behavior. Now, if we look at what states have done in response to the pandemic, they have adopted a variety of different measures, right? They have resorted to lockdowns, social distancing, quarantines, self-isolation, travel bans, facial coverings. And the choice of these measures, usually adopted as a package, have responded to various circumstances, particularly the epidemiological situation in any given place. And as a result of that, the measures have changed. The package of measures has changed as the epidemic has evolved or regressed in any given country. Now, each measure individually may potentially breach obligations owed by states to other states or to individuals. And so the question has been, can the defenses provide cover in the circumstances? Now, if we look at the various defenses from the theme of choice, force majeure requires that the state have no choice but to fail to comply with the obligation. This doesn't seem to be the case here. States have had a choice whether to act and have had a choice as well as to how to act. So force majeure is not likely to give cover to states. State of necessity, unlike force majeure, allows for some degree of choice, but it is again very restricted. The situation of necessity, which involves, it permits a state to act in contravention with its obligations, if that action is the only way to avert an imminent and grave danger to one of its essential interests. So basically, necessity puts the state in a situation where it has one of two options. It either complies with the obligations to the detriment of its interest, or it takes the only way to protect that interest to the detriment of its obligation. Now, again, different states have adopted a different package of measures in dealing with the pandemic. Some have taken no measures at all. These may have been in line with WHO recommendations, and they might not have been in line with WHO recommendations. They may have gone above or perhaps have gone below WHO recommendations. Now, although the question when necessity comes up is specifically whether those measures were the only way for that particular state, so by reference to the epidemiological situation in the state, the specific requirements of the healthcare system, the characteristics of the population, say the age of the population and the density of the population in the territory, this comparative outlook is likely to undermine any single state's claim that their way was the only way to deal with the pandemic. So state of necessity might also fail on these bases. Now, distress instead provides more leeway of action to states because distress is ultimately a defense that is intended for the protection of human life. And given this important aim, it tends to leave the state a much wider choice of options. So in a situation of distress, the state might have a variety of options as to how to act, and it only has to take the option that is the most reasonable in the circumstances. Now, it seems plausible that states might argue, at least some more than others, that their package of measures to deal with the threat is the reasonable way to address the situation. But just as it gives more options and it gives more flexibility, it takes away that flexibility in other respects. So the defense of distress is only allowed where the individual acting on behalf of the state has a special relationship, as the commentary says, the commentary to ILC Article 24, with the individual whose life is at stake. Now, there's no explanation as to what this special relationship might be, but one thinks that if one takes into account the precedents of distress, so situations of ships in distress, that seems to be a very close physical proximity between the act taking, the organ taking the act and the individual at risk. And if this is what is required, then it seems difficult to say that a government has that special relationship with the population as a whole. And so on these bases, again, it is likely to fail. Now, again, the defenses were drafted narrowly specifically. And in fact, I think it's no surprise that they almost never succeed when states invoke them. There have been a handful of cases in which they have succeeded. And one of the interesting things that might come out of this is to see whether more flexibility will be built into these defenses, especially in the context of debates as to the future of the articles on state responsibility. If states do go ahead with a treaty, will they draft them in the same way, or will they include some more flexibility into these rules? Thank you.
Thank you very much, Federica. It's in a way astonishing because the Spanish flu had only been 50 years away when they started working on the draft, that they had forgotten about it somehow, it seems. But that, and your answer, I think, immediately leads to Jürgen. Jürgen, you have brilliantly written about exceptions in international economic law as well as their relationship to general justifications. What is the relation between the general law and state responsibility, in particular regulations of exceptions, limitations, police powers in the trade and investment regimes? And you might want to consider trade and investment separately because they deal with it separately.
Right. Thanks, Anna, for the question. So I will deal with trade distinctly to investment, and I agree with everything Federica said about the customary position. And when it comes to the trade regime, there's absolutely no doubt that on its inception, the framers of the GATT really saw flexibilities as a critical component of the overall set of commitments being entered into. This was not some kind of minor part of the regime. It was absolutely essential, type of logic that would allow member states to adjust their levels of engagement to the trade regime, in line with core socio-political preferences, and also to adjust their commitments in times of pressure, whether that be economic or otherwise. So flexibilities are much deeper and wider in the trade regime than they are at customary international law. And there's a kind of a powerful political economy case here that backs that up. Absent some level of permitted departure it would be very difficult to reach initial agreement on trade liberalisation, or actually even to maintain state confidence in the system over time. So if we think actually of the sorts of trade-related measures at play in the pandemic, and I won't take up too much time on this, but I think there are two big categories. Let me just touch on the first. One big policy measure that almost all states of means that are able to use is export restrictions. They're trying to secure supplies of different types of either prophylactic or vaccines for the supply of their own domestic populace. And if you look at the legal text of the GATT, the original 1947 embodiment of the modern trade regime, we have actually a very strict provision in the GATT, Article 11, which is a per se prohibition on what are called quantitative limitations that apply on both the import and export side. It's kind of the hardest constraint you could imagine in public international law. But actually, there's a flexibility in subparagraph 2 to allow for export prohibitions in a temporary, for a temporary period, where a product is essential to a contracting party. So there's a lot of safe harbor at play in the GATT regime for certain types of trade measures. And the picture is much more complex. And I mean, I could spend, a lot more time, but let me turn to investment. The position in investment law actually is slightly more complex, but we get basically to a similar answer. It's more complex because you're dealing with a heterogeneous set of treaties. You don't have a single kind of multilateral core at play like you do for the most part still in the trade regime, though it's being supplanted by bilateral and regional initiatives. And so if we apply a reverse chronology, so if we begin with newer treaties and sort of track back, the position on newer treaties, so if we look at free trade agreements or regional economic agreements, is pretty much similar to the trade position. What we're seeing states parties do is really build up levels of flexibility far and above the kind of strict customary position. And in fact, they often deep dive and borrow from trade law in framing exceptions in investment law. The slightly trickier question becomes when you go to subject specific, so single subject coverage of investment, older treaties like bilateral investment treaties. There, the flexibilities are relatively constrained. And it is true that some tribunals, mistakenly in my view, have interpreted the operative obligations as simple embodiments of customary pleas, particularly the customary plea of necessity. I think that's mistaken. It's mistaken historically. It's mistaken conceptually and normatively as well. And actually that reading, thankfully, has largely been discredited in the case law of investor state arbitral tribunals. So, bottom line, big takeaway on investment, yes, there's flexibility. It's higher than the customary position, probably lower than the trade position.
Thank you, Jürgen. I think I'm coming back later to you and how you think the cases which come up under COVID, which they will, might be decided. But let me first turn to a question which already was in the room somehow, specifically, what is the relation of international health law to other areas of international law in general? And let me pose my question to Gianluca. Substantively, excuse me, because I'm having a sort of cold, no COVID though. What is the intended relation between international health law and other international law rules like the Chicago Convention on Civil Aviation, or what I find interesting is the Biological Weapons Convention, which actually, even though it was meant to prevent biological attacks, is very much written on the preparedness for pandemics. Has it helped? How is the coordination between the WHO on pandemics and the Biological Weapons Convention? How's the relationship? And that institutionally, how did the coordination between the different international organizations concerned or affected by the health issues posed by COVID, including humanitarians? How did it work? Did it work? Was there any coordination?
Thank you. That's a very interesting question. So when you talk about health law, I would, given the topic, given COVID, so the spread of disease, I would focus again on the international health regulations, because after all, that's the global legal instrument that is supposed to prevent and control this kind of situations. And because we can use it like a benchmark of interaction between health and other values that are embodied in legal regimes and in political regimes and international organizations. So when the international health regulations were absolutely overhauled and revised in 2004, 2005, they opened up the scope quite extensively. They don't only apply to the natural spread of biological agents like COVID, but they also apply to nuclear accident, to bioterrorism, and they are very intrusive in a way. They also talk about the performance of national health systems. It's not just what happens at the border, what happens inside states. For that reason, the potential interaction between health law, i.e. the international health regulations and other legal regimes, grew exponentially. And so the negotiators, member states that negotiated these instruments, were very aware of this, and they tried to ensure consistency between the IHR on the one hand and other legal regimes to avoid conflicts, to avoid risk in weakening health measures that by definition are restrictive, are limiting, and so on. And so it's interesting, if you look in the international health regulation, there is an attempt to ensure consistency. In particular, the fact that when states take national health measures or WHO declares an emergency or issues a recommendation, they need to go through the kind of risk assessment exercise that you find in other bodies of international law, from trade to investment to human rights. So looking at of course, the facts as objective they can be, science, existing standards, contextual risk assessment, the weighing of various interests, and so on. So there has been really an attempt to ensure consistency from a normative point of view. How successful that has been, the jury is out, probably not that much. The second kind of interaction is more synergistic. You mentioned the Chicago Convention. There is a very close connection between health law and aviation law, because especially globalized air travel being a primary factor for the spread of disease. So there are really very deep cross-references between ICAO standards and recommended practices on the one hand, and international health regulations, literally like almost automatic insertion of the various acts taken by ICAO in the normative framework of the regulations. But there is also obviously an element of exception, and that's one of the most controversial part of the regime, because counterbalancing the delegation of authority to WHO, states have retained a lot of power to adopt national measures that can be inconsistent with WHO recommendation, that can even breach some of the provision of the IHR, something similar to Article 20 GATT, that kind of defense in a situation of necessity. And obviously that can punch a big hole in the solidity, in the integrity of these legal regimes. And here we come to these trade restrictions, to the travel restrictions, that however are in a way legitimate most of the time, probably under the regulations. The weakness there is that there is a fairly limited power of WHO to monitor this measure, to ensure accountability, to assess compliance, and so on. So I would say it's either consistency, synergy, and this kind of sovereignty-based exceptions. How does WHO cooperate with other organizations? At two levels, between secretariats or from a normative point of view. Normative point of view, I mentioned ICAO, and other areas where there is a clear normative convergence is nuclear safety. The two famous post-Chernobyl conventions create networks of international organizations to monitor nuclear accident, provide assistance, and so on. WHO is part of these networks. Otherwise, it's largely based on the typical voluntary coordination mechanism. There is a whole interagency system in the UN system on humanitarian assistance, the so-called interagency standing committee, with a system of clusters and lead according to the topic. WHO is the lead, obviously, for public health. Another area is so-called One Health. So the question of environmental and animal diseases that jump to humans, COVID being a prime example. So there is a standing coordination mechanism between WHO, FAO, the Organization on Animal Health, UN Environment. Another one is the nuclear safety that I mentioned, and so on. How well they work? Well, that depends on the funding, depends on the competition between agencies, depends on the clarity of the division of labor, but that's the best we have. And usually they work decently well. You mentioned and I finish with that, the Biological Weapons Convention. In a way, it's interesting because there has been a reverse dynamic there. The international health regulations came on the heels of the United States torpedoing at the last moment the protocol of the Biological Weapons Convention, the inspection and verification protocol. Everybody was very upset with the US. And the US clearly saw the international health regulation as a surrogate of that, as a proxy, as a sort of early warning system for an act of bioterrorism. And so in a way, the IHR was loaded with a political package that could not be resolved in the framework of the Biological Weapons Convention. Very interesting political phenomena are there.
Fantastic, Gianluca. This is super insightful. And I would invite Jürgen and Frederica on that very topic. What would be the legal relevance of international hard and soft law recommendations like face masks, WHO recommendations and statements in the assessment of justification and excuses for prima facie violations from the more general state responsibility point of view to Frederica and from the trade and investment perspective to Jürgen. And you might also take into account the human right to best attainable health, because that could also be a justification, right?
Should I go first, Jürgen? Yeah. So I have never really seen or come across any state that relied on having another obligation as a means of providing a justification, say, of necessity. So you can't really say, well, I have this other obligation, this puts me in a situation of necessity, because that raises questions more of normative conflict. And the defense of necessity is not intended to act in that way. In fact, as it was originally envisaged, the essential interest that the state was intending to protect with the plea of necessity was not one that was legally protected under an international legal right or obligation. And that's why the defense of necessity was thought to be necessary. So when questions of hard law arise in those circumstances, I'm not really sure that they would really be helpful in establishing your claim of necessity. Now, it is true that most essential interests of states nowadays, with the growth of international law, are indeed covered by some rights or obligations. And so you would be able to point to those to demonstrate perhaps how essential that interest is. After all, we know that there is no hierarchy of interests in international law, and what is essential for a plea of necessity is that relative question. So whether an interest is considered to be essential whenever you're invoking necessity will be relative to a set of to the context, and not just the importance of the interest itself, but also the harm that is threatened to it. And in fact, in investment arbitration, Argentina, for instance, has often relied on certain human rights to demonstrate the essential character of the interest that it was protecting, which initially started out as being protecting its financial institutions and ended up being the protection of its population in a broader sense. Now, on the question of soft law and recommendations and WHO recommendations, in particular with respect to measures to adopt to deal with the pandemic, again, because they are not binding, they might be useful, they might cast the state in a good light if they are acting in compliance with the WHO recommendations and perhaps going above in a way that is not hyper restrictive of rights. What I think would be most interesting about those WHO recommendations is the scientific evidence upon which they are based. Ultimately, if you're arguing that your way of dealing with the pandemic is, for instance, the only way to deal with the pandemic in a situation of scientific uncertainty that we were discussing earlier, the fact that WHO provides a good expertise and will provide some scientific basis for those measures might certainly go some way towards addressing the question of scientific uncertainty. Now, the defense of necessity is not excluded by scientific uncertainty. In fact, a measure of uncertainty is allowed in this kind of defense. After all, you're trying to prevent a harm that is in the future. So you cannot establish with any absolute certainty that the harm will occur. All you can say is with the degree of certainty that you can at the time in which you're acting, that that harm will eventually occur, and that these are the measures to address it. And being able to rely on recommendations of the WHO, in particular, the evidence behind them might certainly be useful in that regard.
I guess let me chime in with a little bit of trade and investment discussion as well. On the WTO, it's important to bear in mind actually that some of the WTO legal texts actually reference external norms and give them legal weight within the WTO legal system. So various international standards under the SPS agreement, there's essentially an incentive for states parties to use them in their regulatory kind of activities within certain areas. But more generally, there's the kind of way in which external norms have penetrated WTO adjudication as sort of interpretive guidance. And you know, different scholars take different views on this, but at least measured against past practice, sort of prior to the establishment of the modern WTO legal system, there's been quite extensive use of external norms. Now, is that likely to occur in the future in a hypothetical case involving the pandemic and a challenge to trade-related measures? Well, we've got a problem. The WTO legal system is in hibernation ever since the United States refused to agree to the appointment of a vacancy to the appellate body. So it's basically a standstill. And even were it to reactivate, right, if we had a thought experiment of reactivation, I'm not sure that the modern embodiment of the WTO legal system would ever return to those sorts of adjudicatory practices. I mean, I think at the core of the opposition of the United States, but not only the United States, is that at times the WTO adjudicators have gone off script, that they've acted like a trustee court rather than as an agent of principles. I'm not defending their position, but I do think it has kind of enormous political currency here. If we turn to investment, actually Federica touched on it very nicely. Counterintuitively, actually, you see far greater use of external norms in investor-state arbitration. Often actually for non-legal reasons, I think, meaning that you're not using it, you know, as an interpretive technique to ensure consistency or even correct interpretation, a kind of a, you know, a systemic integration position. Adjudicators will often use external norms to build the legitimacy of the award in the eyes of the disputing parties, or even, in my view, to enhance the reputational value, their own reputational value in an appointments market. So you see extensive level of external norms being used, but there is distinct unevenness in treatment. Some arbitral tribunals do it very, very well. So a case I've used in my writings, Chemtura and Canada, chaired by an ICJ judge, sort of a masterful use in the way in which an external norm can inform an assessment of the legality of a measure in compliance with investment treaty obligations. But others are far more questionable, including many of the awards that related to the Argentine financial crisis. Ultimately, unfortunately, it depends on who is on the tribunal.
Many thanks, Jürgen. And I have one question from the audience to Federica. I put it this way. When you answered my first question, Federica, you started with a no. RCY is not flexible enough. But if we think that it does have customary status, so would you envisage that states might disrupt the authoritative gravitational pull of the RCY? Would they think that the customary international law is not good enough? Will they react and somehow react to this pandemic? And more generally, given that there are good reasons of keeping justifications and exceptions strict?
They certainly might. I don't think that they will kind of disrupt the authoritativeness of RCO. I think they probably try to recast it as reinterpreting the various elements of the articles themselves. I think articles on state responsibility are sufficiently well established that nobody would claim to go beyond them, as it were, but would try to just reinterpret the various elements. And there are some ambiguities in the way in which the articles are drafted, and so things can be improved. For example, distress is a defense that it has very little by way of practice. It was developed by reference to analogical practice in a specific area of the law of the sea, so the question of ships in distress. And the thought that AGO had at the time in the ILC was, well, surely if they can protect life that way, why can't we make this a broader rule? Because the saving of lives of individuals might not always arise in situations like in the law of the sea. And so he drafted a broader rule on that basis. And so the limitation of special relationship only came afterwards in the second reading of the ILC articles, when the UK proposed using distress to justify humanitarian intervention. And so at that point, the ILC said, no, you can't go that far. There has to be a special relationship. So there is some leeway there to interpret a special relationship in a different way. And I would argue, for example, that the real question of the ship in distress is not so much the physical proximity, but rather a question of control. It is literally in the hands of the captain to save the lives of the individuals that are on the ship. And you might be able to say that in a question of public health emergency, it is in the hands of the government, the central government, or in other types of states, also the local government, to address the situation. So you might be able to say that special relationship is not so much a question of physical proximity, but it is really a question of control. How much control do you have over the actual saving of these individuals' lives? And so I think it might come through that way. There are also arguments in force majeure as to whether material impossibility should really be seen as a question of increased difficulty of performance rather than as an absolute impossibility of performance. And that way you would lower the standard there too. So there are certain aspects of the ILC articles that are not completely settled by practice. These are very, very exceptional circumstances, and the practice is relatively scant for the most part. And so there is some leeway there to reinterpret the texts as they currently stand. So I think rather than just sort of disrupt the authoritativeness of the ILC, what we might see is just new interpretations of the various provisions that are in there.
Thank you very much, Federica. And let me turn to a second bunch of questions, and which we partially covered already, and the general scope for states to invoke emergencies and exceptions. And sorry to overburden you in the moment, Federica, but what would be very interesting, and I think Jürgen, you would also like to comment on that one from the trade and investment perspective again. What would the legal remedies look like under RCEWA, and maybe Gianluca, you want to chime in on ARIO, so the Articles of Responsibility of International Organizations, especially given that there was a lot of discussion around on ESIL Talk. So Marco, thanks for that. On the state responsibility of China, which might weigh heavily in the current discussion.
So if I may, I'll probably focus on China just to make the discussion clear, because there's a number of questions that arise from your questions. So there's questions about standing, reparations, and implementation, including jurisdiction and countermeasures that might arise both for states and for international organizations. So the one thing that is most interesting to me, and that has been most interesting to me in all these debates, is the question of compensation. So let's assume that China has in fact infringed a rule of international law, perhaps the duties of notification under the IHR, or perhaps the no harm principle, right? It failed to prevent a harm occurring in its territory to the rights of other states. How do we establish causation between what China has failed to do rather than done and the actual damage that is potentially being covered by compensation? Now, as the potential wrongful act of China is an omission, right? And omissions can be causes, if only in a normative sense. They cannot be bad for causes, but they can certainly be causes. But this doesn't mean that they necessarily give rise to compensation. Now, the ILC doesn't establish a standard of causation in the ILC articles because it says it's a very complex issue that needs to be looked at on a case-by-case basis. But if we look at the ICJ, for example, it has taken a very, very strict approach to the standard of causation, specifically in cases of omissions. So if we look at the Bosnian genocide case, for instance, the court required a sufficiently direct and certain causal link between Serbia's omission on the one hand and the commission of genocide on the other. And it explained that these tests require proof that the damage would not have occurred even if the state had complied with its obligation. Now, from what we currently know about the coronavirus, and in particular about asymptomatic transmission, it will be very hard to argue that even if China had complied with those obligations, the virus might not have spread. Now, perhaps the virus would have spread less, perhaps the virus would have spread to the same extent. It's a counterfactual. It is incredibly hard to prove with any degree of certainty. And I think Marco, commenting on the Bosnian genocide case, said it was impossible. Correct me, Marco, if I'm wrong. And even if causation were established, let's say we can establish causation between the wrongful act of China and the damage, then there's a host of questions about contributory fault. Now, the ILC articles say that there can be multiple causes, that this does not exclude compensation by anyone who contributed to the damage, but there's a question of contributory fault. To what extent did the lack of preparation of other states contribute to the damage that has eventually been caused? And depending on the degree of that fault, of that contribution to the damage, ultimately the amount of compensation that China owes could potentially be very, very little. So, you know, to me, this is the most doctrinally interesting question, but of course, this is all a bit up in the air and a bit all academic, if I may say so, because there is just no forum where this could be taken. I think the international health regulations do contain a dispute settlement provision with potential arbitration, but China hasn't consented. The no harm principle is a customary rule, so you would need to have either arbitration or ICJ optional clause declarations, and China just has not been forthcoming with that. So, you know, doctrinally it raises hugely important issues, but I think in practice we might not be able to see the answers to those issues.
Thank you very much, Federica. Maybe Gianluca, you want to chime in on the attacks on the WHO, we all know from whom, and the responsibility of the WHO.
Yeah, well, leaving aside what Trump may have said, I think it's very transparent why he said what he said when he said it. But I also find it a bit difficult to imagine a situation where the international responsibility of WHO may be engaged. First of all, what primary rules could WHO have breached? I guess based on the international health regulations. So in a way, there should be a clear case of negligence, or if you want to believe Trump, of collusion with the state, such that in a way it perverted the integrity of its functions and led it to breach its functions under the IHR. At the same time, we need to, and I think Federica alluded to that before, we need to look at the context. New virus, unknown, with science developing every other day, with an incredibly fast moving situation. Frankly, which public health institutions can be considered like on top of everything to the point of imposing a huge standard of diligence that are not supported by the available science? Second, where is the causation? Who would be the victim of WHO's unlawful act? And here I go back to what Federica was saying, the co-causation by the evident, frankly, negligence that many states have shown in sitting on the hands until the crisis exploded. And third, remedies. What kind of remedies could be imaginable from an international organization? Certainly not financial compensation to the tune of billions and billions of dollars. That obviously is just wishful thinking. An apology, or it goes back to the typical political mechanism of international organization, not re-electing Dr. Tedros, overhaul of the secretariat, increasing the control of member states on the actions of WHO, which will be counterproductive. So it seems all very a bit difficult to grasp in purely doctrinal terms.
Thank you very much, Gianluca. I think we all think the same way, but it's still a question to be discussed because it's out there and it's discussed in the media, and the WHO didn't only get good grades for sure. Now let me turn to Jürgen, and it's a little bit a question which comes back to the first round of discussions we had. So in the specific field of trade in times of COVID, where a lot of countries have imposed export restrictions, as you have mentioned, and you said, well, trade law is fine, it's pretty flexible, but I remember reading an article by one of your colleagues at EUI, Hökman and Chad Baun in Foreign Affairs, basically asking on it might be too flexible. A WTO law might be too flexible, and that comes back to the question our president has posed in the last panel, because it allows states to impose export restrictions, which actually makes the international trading system leading to an even more unequal and discriminatory trading system. How do we deal with this? So there's this paradox. We allow states to go it alone, and we destroy by that somehow the push to international cooperation and sharing of resources. They were very smart, as economists usually are, and they said we could have done an international treaty before we knew where exactly the pandemic would be worst and where the supplies exactly are, because given the international supply chain, states might be retaliating. So a little bit, they could have done the treaty if they would have been under a veil of ignorance of where the consequences of the virus really lie. So my question is, isn't trade law too flexible and that inhibits actually international cooperation?
Right. That's a great and extremely difficult question. I'd say it's a qualified yes, that there's too much flexibility. You know, without some ability to cater to the immediate health needs of citizens, it would be politically impossible to commit to a trade compact. So just cast your minds back to February, you know, in northern Italy, in the news media reports of what was happening in hospitals in the north of Italy, or the horrifying images of mass graves in the outer boroughs of New York City some months later. Clearly, there has to be some ability for states parties to divert production choices to the immediate needs of their citizens where they're under frontline pressure. But I think you're probably right. There's too much flexibility. There's a targeted exception within the actual provision on quantitative restrictions that is more generous than what we see in other flexibilities throughout the WTO. So what might be an answer? Well, you know, the problem with unilateralism is that you get, you know, significant kind of distributional impacts globally. You can get over-servicing of, you know, PPE equipment or even vaccines to richer countries, with poorer countries, and this is the thrust of your question, you know, suffering or being reliant on a donations model, which is essentially unworkable. So what's the answer? Well, I don't have a magic answer for you. The bottom line is we need new multilateral architecture to kind of challenge and collate those sorts of resources and to ensure good distribution. There are green shoots of cooperation, right? So we have the COVAX initiative, where we have a number of states parties seeking to pool demand amongst themselves and then cross-subsidize to ensure provision of vaccines to poorer countries. But if I'm honest, I'm not particularly hopeful that we're going to see a level of multilateral commitment of what would be ideal in this setting. There's a decline in a commitment to multilateralism, certainly in the trade regime, spearheaded by the United States, but I don't think it's an outlier. We're seeing a big shift to renationalize production, so shorten supply chains, renationalize production that, again, is not just in the United States. France has announced this in the healthcare sector. And more broadly, health concerns are becoming securitized. So what you're seeing are countries like the United States, China, and Russia presenting health not in its, you know, its pure sense, but as part of a security competition. So all of these factors point against the kind of ideal structure, which would be deeper levels of rules to allow for distribution of vaccines to ensure minimum levels of vaccination across the globe. So what's the most likely solution? Let me be half optimistic. The half optimistic position would be a second best. I think there'll be a greater push to regional blocks. So what you're going to see, I think, is encouragement of supply chains that operate on a regional level. And actually, when you do a deep dive into supply chains in the healthcare sector, they are often organized on a regional level. So I think we're going to see more movement in that space, so that you'll see blocks within Europe, within Southeast Asia, etc., etc. It is not perfect. It will still leave the poorest countries exposed, but it's probably the most feasible solution on the trade front.
Thank you, Jürgen. To Gianluca, and that was an earlier question from the audience, would you think that naming and shaming by the WHO would help to nudge states towards cooperating? And let me add to that question from the audience, since I'm concerned in the moment with rewarding in international law, maybe naming and praising for those countries who do give, who do share.
That's a good question, and many people have been asking the same question. Why is WHO so hesitant to point fingers, to criticize? I think there are, would it help? Depends, but there are two, I think, main explanations why WHO is so hesitant. There is a feeling that the international health regulation, which after all is the instrument that guides the action to the Secretariat, does not allow for that kind of publicity as an instrument for accountability, for inducing compliance, deterring non-compliance. And second, it's not in the DNA of WHO. It's more sociological maybe, but I think there are institutional cultures that become quite prevalent in different international organizations. In the case of WHO, it's very much a culture of cooperation and certainly not of antagonism or of become judgmental. So that certainly the WHO doesn't feel like it's either legally permissible nor politically expedient to start pointing fingers. I think that it would be a step forward because it would start at the very least showing gaps, even without criticizing, but showing patterns of non-compliance, which may not be due to bad faith or willful non-compliance, but to lack of resources, to systemic problems that need to be addressed. If you don't start identifying those problems, and in a way also identify the countries that share those problems, you don't go in the right direction. You don't start learning the lessons that can try to close those gaps. I personally think that if WHO, Dr. Tedros, had started criticizing Boris Johnson or Donald Trump or Xi Jinping, the reaction would have been very negative. It would have closed doors. It would have been counterproductive. So at that level of political sensitivity, I really don't think the naming and shaming is a concrete option. You mentioned naming and praising, and WHO is still paying dearly for the praises that he heaped during January on China, which I found really excessive and unjustified. People are wondering why. And anecdotally, I personally think that it was in part because there was a recognition that China was taking exceptional steps. Everybody was sort of shaking their heads how brutal the lockdown on Wuhan was. And a few weeks later, we all followed the Chinese example. But also because China is a difficult client. And so it was felt that only by recognizing its sacrifice and its commitment, you could keep it engaged and you could keep it cooperating, since after all, it was the country of origin of the disease. So it's a judgment call. I personally don't think that the naming and shaming that we have in mind would be productive, but there should be other less antagonistic tools for accountability and to induce compliance.
And Gianluca, as you speak, there is a question coming in. Is there any, which you partially answered, I guess, so you might want to make it very short. Is there any way to recast China's conduct as a violation of WHO constitution? As there is a compromissory clause, is there a compromissory clause in that treaty?
Yeah, very good question. And we had a podcast with Marco and Filippa a couple of months ago where that same question came up. Yes, there is a compromissory clause in the Constitution, that's Article 75, that allows either the Health Assembly to solve a conflict of interpretation or implementation. Otherwise, it recognizes the jurisdiction of the International Court of Justice. I think the issue is whether you can recast a possible breach of the international health regulation as a breach of the Constitution, because after all, the IHR will be lex specialis, I believe, vis-a-vis the Constitution. But if that in a lawyerly way could be done, the compromissory clause is there. And I think that several countries are looking at that and are either keen to use it or afraid that it may be used.
Thank you, Gianluca. That almost brings me to the end. I would, if you have a very short answer on, in order to connect it to the first panel, if there will be cases brought, like, for example, the WTO DSB in its current form, or to investment treaties, or to the ICJ, will those bodies be able to consider all the aspects of the issues? What will be the role of scientific and other forms of expert knowledge in such assessments? And you may either speak of how you think those bodies are going to do it, or how they should be doing it. Very briefly, please.
Should I go ahead? Okay, great. So let me just speak very quickly on the WTO, and I listened very intently to the first panel, which I thought was excellent. You know, and I'd already alluded slightly to this, but actually I think on the treatment of scientific evidence, questions of uncertainty and scientific consensus, issues of the so-called precautionary principle as it's applied in WTO law, I think WTO adjudication has done, has handled some of those complexities in quite a sophisticated way. It draws quite a clear-seated division, not always, between risk assessment, risk management. So there's much to be learned actually from WTO jurisprudence in dealing with how law approaches, science and scientific uncertainty. I doubt though that we're going to see a lot of WTO adjudication here. Think about 2003, 2009, 2003, avian flu, 2009, swine flu. In 2009, you saw very similar policy measures, including export restrictions. Very few WTO cases. There's a strong reason for that, because basically most developed states are all playing the same game. So there's not a lot of incentive to throw the first stone, because the stone will be thrown back. Investment law, though, the risk is much higher that you're going to see a claim, because with foreign investors simply are concerned, for the most part, of the impact on the profitability of their investment in the host state. So if a host state does something, whether it's an export restriction, whether it steps in to stop investment by another state, like Germany's blockage by the United States' investment of a German pharmaceutical company, that could well trigger an investment claim. And we know that's happened in the past. There have been claims against export restrictions in the investment law field. And some of those treaties have very few flexibilities or limited flexibilities. So again, the legal question there would be much more complex and much more difficult to defend from a state's perspective.
Thank you, Jürgen. We are really running out of time, but if Federica or Gianluca would like to chime in.
I'm okay, thank you.
Okay, then let me thank you, all the panelists, also from the first panel, I think, for what has been an incredibly interesting discussion and insightful discussion, at least for me. And I would like to thank the audience, the questions from the audience. I hope you enjoyed it. And I think I quickly hand over to Paul.
Well, thank you very much. And this has been an equally good panel, very well informed and enlightening. So I'm very grateful to all of you, the panelists, Gianluca, Federica, Jürgen, and also to you, Anne, for some skillfully moderating it. So the recording of this webinar will be video cast, and we will provide links to that cast both on the ESIL website and the SCILJ, the Stockholm Center for International Law and Justice website. So I want to thank also the attendees for taking part in this event. And just to say, stay safe, and I hope to see you all in Stockholm in 2021. Thank you.